for line. And I was like, right.
Good evening, everyone, and thank you for joining us for another episode of Advocacy. I have Ms. Lisa Wilson here, who is our education ambassador. I am so excited to have this tonight because I think this talking about a filing a state complaint, man. Lisa was talking offline, but I'm in the midst of it right now. And it is definitely a lot of work and it can be quite frustrating for the parent and the caregiver. So I just want everybody to tune in and really listen to this process, take it in, and because I promise you, it's a lot when it comes to filing a complaint, which most people steer away from because of all of the headache that comes along with it. But at the end of filing a complaint is a bucket of gold. What is it? At the end of the rainbow, it's a bucket of gold, but it's not fun going through the process, but it is worth it. So I'm going to turn it over to Lisa. Lisa, I'll get your slides together.
All righty. I just want to say good evening to everyone. This is somewhat of a heavy topic for us tonight. While Paula has just embarked upon her first administrative complaint at the end of her daughter's journey, I've been enmeshed in this process for the last 5 years. I have successfully filed 4 administrative state complaints. One did not return favorable, and the verdict is still out on that. But I think it's important for parents to understand that in light of the current circumstances, with the essential closing of the department, the constructive closing of the Department of Education, who is home to the Office of Civil Rights, where parents can file complaints for disability and retaliation and other things with the Department of Education. I think right now in the shifting policy landscape, because recently in the news, they have announced that they're going to be shifting the complaint, the federal complaint process to the Department of Justice, and they're going to be sending the special education component over to Health and Human Services. And as you can imagine, advocacy groups, parent groups, everybody is just up in arms because it's going to put special education under what we know it to be a medical model. And that's just not what the intention of IDEA, that just wasn't the intention of the legislation. And then with the office, the Department of Justice absorbing the thousands of pending federal complaints, I think that we have to really be sober when we, understand what is likely to happen. And what I suspect is that there's going to be a top-down review of all of those complaints, and they're going to be looking for ones that they can just outright dismiss. The Department of Justice has a different standard. They deal with civil and criminal, violations of the law. And so to bring in special education, I'm just not certain that they are going to have the subject matter expertise that it takes to appreciate these complaints. But I just wanted to give the federal perspective first. Today, we're talking about the state perspective, and it's equally as gloomy. I think that parents really need to understand the seriousness of this moment that we're in right now, because the rights that our children have been afforded through the multiple layers of legislation, their rights are shrinking. And they're shrinking because the agencies that are responsible for enforcement and monitoring they're shrinking. We live in Maryland, so we're going to refer to the Maryland State Department of Education, also known as MSD. It's under new leadership. It's kind of been a little bit of a situation going on there. So we do have a new director, Dr. Masudi, who has a very impressive resume and appears to be overly qualified for the position with all respect. However, she needs some time to get her feet beneath her. You can't come in with a hammer and see everything as a nail. So I understand her slow and methodical approach, but I'm just not so sure that she has a total appreciation for the trauma that the families are undergoing because of the naked discrimination against our children and failure of our children to receive FAPE, which, as you know, that is free and appropriate public education. But I'm hoping that we have a brighter future here in Maryland. I'm just not as optimistic, but I'm not going to be a Debbie Downer. So what we want to talk to you all about today is the administrative complaint process. In no way are we encouraging everybody to race out tomorrow and file a complaint. What we are asking you to do is to take a step back and do an in-depth analysis of your relationship with your IEP team. And then we're also asking you to look at that IEP top to bottom to ensure that it is reasonably calculated and your child has the appropriate accommodations to access their education. And when you observe or encounter failures, systemic failures, individual failures, I believe personally that as a parent and advocate, you have a moral duty to advocate for your child. And in that advocacy, one of the tools is the administrative complaint process. So I wanted to get that off my chest, Paula, because I don't want people to think that this is all about attacking the IEP team, attacking districts. This is not what this is about. But if we're all going to be honest, we have to understand that there are systemic failures that are affecting our children. And I look at it very seriously, Paula, because it's not only affecting my child in the 5th grade. He just finished the 5th grade. Mm-hmm. It's affecting my child for the rest of his life.
Exactly.
My child right now, because of the systemic failures and the naked discrimination and naked retaliation, my child has multiple years of educational gaps that we may never close. So this is personal for me. And I take this part of my advocacy journey very serious. And should anyone under the sound of our voice need any assistance with completing an administrative complaint, please contact Advocacy without delay, because these issues are time sensitive.
Correct. Okay. Well, let's go on to, I'll go start with the slides that you have provided.
Yes. So we try not to do a lot of heavy legal jargon here because we want to relate to parents on a parent level. But it is important that we give you some definitions and some key facts. This is a formal process. You do have to, there are certain criteria that are required to be in the formal complaint, but you don't have to use the state's form. If you're going to write it in a Word document, you just need to understand what the criteria. For example, you have to list the address, the name of the school. You have to identify the school where your child is, there's just some mandatory things that need to be in there. However, and I'm not sure, Paula, if you use the state form, or did you do it free form?
I think I did a free form.
Okay, but you matched it up against the
I
required
did.
criteria.
Yeah.
So
Mhm.
this
To
is
make sure all of the information was in there. And I do think that's best if you're going to if you're not going to use the form that they provide, just match it up so that you know that everything that they're asking for is in that form, is in your document.
yes. And for me, so the Maryland State form, it is 2 pages. And um, just for example, back in last year, I filed a complaint with probably 10 to 12 violations, allegations. So as you can see, that form is just not enough. You always have to add on. So it
Mhm.
makes sense to, do what Paula did. But when you do this, this is a formal written request asking your state educational agency, also known as SEA, to investigate whether a school district has violated special education law under Part B, and there are different parts, but right now we're talking about elementary school, elementary age children, not the little ones.
Mhm.
The little ones are under Part C. Um, Part B of the Individuals with Disabilities Educational Act. So the most important things we want you to know is that this is free. You don't need an attorney. This is one of the very few legal processes in this country where you can file without an attorney
Mhm.
and successfully have an investigation conducted by a government agency. This is accessible to everyone. Now, what I found to be interesting, and I found this out because I found a federal complaint against Prince George's County school system, is because a couple years ago, the superintendent refused to turn over some information to Maryland Disability Rights Organization. So it's not just a parent that can file a complaint, an organization can file. So perhaps if you're familiar with the ARC, the ARC has joined into litigation, on past occasions and currently, but this is not limited to a parent. So organizations can file. For example, and I'm just going to use this hypothetical. Um, Imagine that students with disabilities are being suspended from school, which is disciplinary, at a higher rate than their non disabled peers. And my organization would like to, investigate it. So we engage the school district. They pretty much don't cooperate or give us, any type of information to help us, render a conclusion. So we're trying to determine if this is discrimination. Well, once you get some of the data is public, once you get enough data, my organization, we would have a right to file an administrative complaint to determine if the school district is violating special education law. And since I mentioned suspension, I will say, and we're going to do another segment on this, but when it comes to discipline and disabled children, there are some very important steps that need to take place. For example, if your child is going to be suspended more than 10 days, they need to have what you call a manifestation hearing. And so we'll talk about that in other meetings. But I'm saying this to say that it's not limited to a parent. An organization can also file a complaint. And this covers individual and systemic issues, kind of like what I was just alluding to in my example. So we can go on, and so we can help you understand what your rights are on the next slide. And by now, our audience should be well aware that their children are entitled to special education services at no cost. And those services, which are connected to FATE, must be tailored to their unique needs. And as you know, Paul, I love to bring up Andrews, the Supreme Court, unanimous Supreme Court decision of the Andrews decision. It talks more specifically about that tailoring it to their unique needs. There's no de minimis is no more. Our children must be able to make progress. Now, that progress is going to look different for everyone's child because there are nuances to this. All of our children have a spectrum of disabilities and abilities. But this is something that you are entitled to at no cost. Prior written notice. This is so important. You hear us, we talk about PWN. This is very important. A school must notify you in writing before changing your child's identification, evaluation, or placement. The PWN, most people just associate it, Paula, with it's something that must come within 5 days of the IEP meeting. But this also is very important because anytime they make any changes to your child's IEP to include placement and evaluation, meaning assessments, a PWN must follow. I like to think of it as the PWN being the controlling document in the process, secondary to the IEP.
And I'm glad you mentioned that too, Lisa, because I was under that same impression, is that was more so used to notify me of an upcoming IEP meeting. But once I filed my complaint, the PWN was so important, and I didn't realize that. But I'm glad that I had my daughter's school files, because that was all through her school files. And when I submitted proof or evidence, I referred a lot to the PWN.
Mm-hmm. It's very important. And then informed consent. The school needs your written permission before the initial evaluations or beginning services. So recently, during an IEP meeting, my son's school, they finally, not the school, but my son is in a non-public, but the resident school district, they wanted to do an assessment on my son, and they could not proceed with that assessment until I gave written approval. So these are your rights, parents. This is not for you to be, you don't have to be confrontational about this. These are your bona fide rights. And it's just so important that you just understand what your basic rights are, and then you can build off of that going forward. And access to records. This is important, and I like to tell parents that you should always request access to your children's records, and also include a blurb in there about FERPA. We did a whole segment on FERPA, so you can definitely pull that up on Advocacy's on our history on your whatever social media you use. But you have a right to inspect and review all of your child's educational records at any time. And schools like to give a little pushback. They like to stall. They have 45 days by law after you do a written request. Many times they just ignore it because it's very difficult to get accountability for them in this area. In fact, the office at the Department of Education that monitors and enforces FERPA, again, the whole agency is being dismantled. So school districts know that no one's watching, so they can get away with whatever. But this is very important. Service logs, when your child is pulled out for their service hours, you need to understand what's happening, because how can you be an advocate for your child when you don't really understand what's in the record and what to advocate for?
And I will say too, that service log for me was very important, because I filed my complaint saying that they were alleging that Morgan was not receiving her speech services. And once they went to her school records, there was no service log for months at a time. So Lisa is right. That service log is very important. If your child is receiving occupational, physical, whatever, it should be a service log with a date of what they did, the date that they met with them, and everything. So that's how I want a portion of my complaint, because there was no service log for months at a time for Morgan Speech Services. So what that alleges is that she's not getting her speech services.
Exactly.
Hmm.
Once in an IEP meeting, I don't want to digress, but I had a supervisor tell me that I wasn't going to get the service logs. And she was absolutely correct, because to this day, I've never received them. I was pretty disappointed. But again, I filed a complaint. MSDE really didn't help me out. Excuse me, I forgot to bring my water. I'm sorry. Can you go on to the next slide and read it for me? I'm going to grab some water.
Yes. Okay. So the next line talks about who can file a complaint. The eligibility to file is deliberately broad under federal law. Parents and guardians. Any parent or legal guardian of a child with a disability, you are definitely allowed to file a complaint. And I think Lisa talked about this in advocacy organization, a disability rights group, parent training center, protection and advocacy agencies. And again, I think Lisa was alleging to the fact that if you as an agency, if you're requesting documentation and you're asking the school and you don't get it, you can file a complaint on that. Teachers and staff, school employees who observe violations. Now, we all know that we've had some teachers, some educators on here. And when I went to the conference in Utah for Council for Exceptional Children, it was amazing to me how many teachers said that they stood up for their students, because they saw that there was a lot of violations going on. And I think, again, for me, it kind of goes along. I commend you when you do that, because it kind of goes along with the police department. When you see a police doing something wrong, a lot of people sit back and say, well, we bleed blue. We don't, turn against each other. But keep in mind that these are our children and these are our future. It may not be your particular child, but if you have signed up to educate these kids, I believe that you have a responsibility. So if you see a violation going on, you should be able to file a complaint. And community members, any individual, including someone from another state, again, if you recognize or understand that there's a violation going on, you should be able to file a complaint. And I will be honest, when I filed my complaint, and I'm sure Lisa will say the same thing, I didn't just do it for Morgan, but I did it for all of the students behind Morgan, all of the students that are with Morgan, because if they're doing this to Morgan, I don't believe anybody at her school had an axe to grind with her. I believe that for whatever reasons, the shortage of teachers, the shortage of speech therapists, the shortage of all types of therapists, that does not have anything to do with our students getting what they deserve or what is outlined in their IEPs. So if they're doing it for Morgan, I'm shedding light on the fact that most likely it's being done to other students as well. So me filing a complaint, I feel like I'm not just doing it for Morgan, I'm doing it for other kids.
That's right.
Mhm.
I think that is a powerful statement. And in fact, earlier this week, I received a change.org petition signature. There's an elementary school in Prince George's County, Lake Arbor Elementary. There was a special education teacher. She quit. And I don't know did you see this, Paula? But it's all over the internet.
Okay.
But she quit because of how the disabled autistic children are being treated by that school, the administration, and I mean at large the entire school district, because it's just an open secret in this county of how people really feel about disabled children. So she wrote this long dissertation, and then she went back and added pictures, and I'll make sure to send that to you because I want you to sign that petition, Paula.
Okay.
But I'm happy she did that because she quit at the end of the dissertation that she wrote. She quit.
Yeah, that was part of the safest.
It's- and I'm glad that she did that. But what really would have been the most appropriate thing is for her to file a formal complaint
Mm-hmm.
with MSDE, you know. So while we're happy that she exposed some of their dirty laundry,
Mm-hmm.
she really should have I mean, she was a person who was up close and personal. She knew
She
all the
saw a
ins.
lot of stuff.
So I wish she had filed a complaint because the petition is good, but
We would
we,
like to know what's going on, and
and
she won.
we want an investigation and we want
Mm-hmm.
change.
Mm-hmm.
You know, we don't want to trust that the district can police themselves. You know, and she blasted this email thing out to every employee of that school.
Mm.
I tell you, this thing is all over.
I have to go look that up.
I'm gonna send it to you shortly, as soon as we have.
Okay.
But she was a perfect candidate to stand up for all the disabled children in PG County. But
Okay.
we appreciate her. So this is important. So what can you file a complaint about? We can go on to the next slide. Any violation of Part B of IDEA or its implementing regulations, which are found in 34 Code of Federal Regulations, also known as CFR, Part 300. Procedural violations, missed IEP meeting timelines, meaning if your child's supposed to have an IEP meeting annually and you go an entire school year and they don't hold a meeting, that's a missed IEP timeline. Failure to provide that written notice. That written notice must be accompanied with any changes to your child's IEP, and it certainly must follow all IEP meetings to summarize what happened in the meeting, and also to acknowledge if the parent made a request, if the school is going to accept the request or deny the request. They have to put a justification as to why.
Okay.
And then not conducting evaluations within the required deadlines. So this is very important. Those are procedural violations. Then you have what you call substantive violations. And that's what we always talk about, the denial of FAPE. And that's a pretty broad umbrella. Inadequate IEP goals or services. Another mom that I work closely with, she was able to figure out, she's heavy into data mining and things like that. And she was able to figure out that the goals in her son's IEP were multiple grade levels below where he was. So that's inadequate IEP goals. Inappropriate placement decisions. This is really important. You know, this is probably where I should have been a couple years ago. But if your child isn't thriving, if your child isn't making any educational progress in their current placement, you have a right to ask the team to consider changing that child's placement. And if they deny you or continue, and the child continues to fall behind, then a closer look can be taken to determine if that child is in an appropriate or inappropriate placement. And if you believe that your child is in an inappropriate placement, by all means, you can file a substantive violation allegation.
Now let me stop you right there, Lisa. I know with Morgan did file a complaint, and I think hers was on the substantive violation when
Mhm.
she was, removed from Charles County, and then she was put at a private placement school.
Mhm.
So naturally, as we're talking, everyone knows that I filed a complaint even against a private placement. I would like to really re-emphasize the fact, and my lawyer told me this when I did get Morgan out of my neighborhood school. He said, don't sleep on the private placement as well, because the private placement, a lot of the times we think that because we're getting them out of their neighborhood school and we're getting them in a private placement, that all is well. That's not the case.
Mhm.
And so even with that, I fought myself, because when I look back, I should have even had, when I didn't see progress, I should have even asked for her to be removed from that private placement school.
Ooh, Okay.
And that to me is so important. And I emphasize that because a lot of people think that these private play, and don't get me wrong, again, we're not trying to push anybody to file a complaint. But what I will say is one of the things I filed the complaint on is the fact that I wasn't seeing progress. And they were saying one thing and I didn't see it. So for me, when we even had observations, I did not see any of the things that they were saying. So for me, I would even have done differently if I had it to do all over again. I would have done differently a couple of years ago, and I would have removed her from that school because I felt like if that was a private placement and I moved her out of our neighborhood school for her to be there, I was expecting, naturally, you're expecting more progress. I didn't see it. And they were really telling me that it was there, but it wasn't. So I just caution anybody, even if you have to sue your school system and get them out, don't just assume that that private placement, if there is a private placement, don't just assume that they're going to just soar there and they're going to be on top of their game all the time. They're not.
Right. Well, I think that it's all relative.
Mhm.
And I think that's where the parents' advocacy, you really need to be in the school. You need to see what is happening, what is going on. My son's school, at this point, things are looking very positive for me because
Great.
he has an entire team that's
Mhm.
kind of wrapped around him. Very few things fall through the cracks. And so I think that, and then I've heard some horror stories. There's another lady mom who spoke at a public event that I was at. Her child was in a non-public placement, and he was physically assaulted.
Yeah.
You know, so there are some that are really like there are some that are really unattractive, but it's a big decision that
It
you
is.
know when first of all when you make that decision, it's a big decision, but then you have to take it one step further, like what we're talking about. You really need to be hands on and involved. And even though Morgan was at a wonderful school, it just may not they may not have been able to meet her needs.
Exactly.
And so another school may have been able to meet her needs.
Exactly. And you can't leave it up to the school to tell you that. A lot of the times they don't.
Yeah, they
That's the
don't.
unfortunate part about it. They don't tell you.
Yeah,
Mhm.
yeah. So one of the things in my son, his school district, they unilaterally made a decision to place my son. So he goes to school 2 hours from our home, and I'm convinced beyond a shadow of a doubt they did it so that I would not have access to be an advocate to him. You know,
Mm.
and that is a personally offensive situation for me because I've always been physically present, checking in on him, doing observations, very close where I can like put a finger on him,
So
you know.
are you referring to more so that they didn't think that you would go and observe him as much because he's 2 hours away?
Yeah, well, they're constructively obstructing my ability to be a meaningful member, legal member of the IEP team
Okay.
and to participate. And that's something we really need to talk about that at another meeting, at another presentation, parent participation. It's codified into law. You have a right to participate in every aspect of that IEP process, to include the drafting of it.
Mm-hmm.
How many times do you come to the meeting and they say, here's your copy of the draft?
Yeah.
Well, I should have been a part of that drafting process. It
Mm-hmm.
shows you how they don't even see you as equal partners.
Yeah. Now I've never had the option to participate in creating Morgan's IEP. So I'm in full agreement with you.
Yeah, so that's kind of that's a heartbreaker for me. But
Mhm.
so we talked about systemic violations, district-wide policies that conflict with IDEA. Now it's interesting because I have challenged MSDE on this because in my personal situation, they denied or terminated my son's special education transportation because we moved, and they they did so under the premise of their internal administrative procedure, which is an internal policy. But as anyone who's remotely familiar with the US Constitution, there is a supremacy clause that says you cannot, a state, an agency, government, you can't create a policy that conflicts with federal law or undermines, because federal law supersedes in every situation.
Okay.
And so my son was already legally entitled to his transportation in his IEP, but they use their internal policy to terminate that benefit in his IEP.
Mm-hmm.
And so MSDE did not find in my favor. So we started off the conversation talking about where we are. It's a textbook scenario. So blanket restrictions on all services like extended school year, that's kind of been a thing, a little litigation history with that, because some school districts were, limiting how many children can attend, and that's not what it's about. It's how many are eligible, not how many seats you have. It's how many are eligible. So extended school year, that's a tricky one. And then just patterns of non-compliance. Again, I'm just using my school district because it's been in the newspaper. This is public knowledge. Several months ago, they did a news spread because children weren't getting their direct support aids. I think the article said it was 80, between 80 and 85 children who were supposed to have direct support aids, and they didn't. The newspaper did like a little investigation, and then of course the school district started stretching and bending themselves into a pretzel. Oh no, that number isn't right. But any number is devastating.
Yeah.
That's 80 children, in my humble opinion, that are languishing in a classroom because they don't have that one-on-one support, and the teacher doesn't have time to give it to them. But the IEP says they are entitled to it, and the school district wasn't providing it. So it hit the news. So
wow.
What's important here is this timeline, and we can go on to the next slide, is that you have 1 year maximum look back period to file your allegations. Now, some people, Paula, you do one thing to that family, they're going to file. Like they'll just keep filing. I can't keep up with that. Like it's
a lot of work. I'm not going to lie.
So what I do is I wait until the end of the school year, and then I start gathering all my notes and my facts. So my complaints are pretty lengthy.
Okay.
But you can do any approach, what works for you, but it's about what you can manage. And it's a lot.
Because it's a lot of work. I promise you, when I did it, it was a lot of work.
It's and you're still kind of in it. So it just kind of lingers on. So what does this mean? The alleged violation must have occurred within 1 year before the date the SEA, which is the state educational agency, receives your complaint. Any allegation older than 1 year will be dismissed as untimely, regardless of the merit. This is why it's so important. You should have your special education journal, calendar book, write everything down, keep track of your dates, because this is very important. And so how does this compare? Due process hearings have a 2-year statute of limitations. The state complaint deadline is tighter, so filing sooner is always better. So we don't want you to confuse this with due process, because those are two different processes. But with due process, you do get, 2-year statute of limitations. But I have my own opinions about due process. We'll talk about that at a later date and time. Because that's like a mini trial, literally.
And if we're just doing the complaint for 1 year, imagine with the due process. It is a lot of work. I will say that it's a lot of work.
Most people will not go to due process because it's intimidating, and most people are given a recommendation that you shouldn't do it unless you have an attorney.
And then it becomes expensive.
Right. And so, but me, I feel that's something that I'm capable of handling on my own, but that's because I'm a special education nerd. And so
Yeah.
I've become very educated about this, but it's just not a pathway that I believe is viable because of the unequal balance of the school district. In my case, I think they have a $4 billion budget. They say, oh, it's not that much. It's three. I don't know. Okay, so you're looking at an agency throwing the full weight of their resources against you. So it's just not a pathway that I believe is viable for many parents, unless you have an attorney. So real quick, we're going to move into how do you do it, okay? And we have on here, and the next slide, these slides will be available, but you can type into your Google search engine 34 CFR 300.153. And it's going to tell you exactly what needs to be in there. It needs to be written. It needs to be signed. No specific form is required. Identify the violation. You don't have to know which code of federal regulation, which CFR they're violating. You can just state it in plain language. Like for me, the school district terminated my son's transportation that's listed in his IEP. The investigating agency will go and pull the code of federal regulations and also the state violations and regulations. They'll make it all pretty and fancy. You don't have to be a lawyer. Just state in plain language. They're refusing to give my son a functional behavior assessment, and he's having a lot of behavioral issues. Just plain language. And then there is a section you do have to propose a resolution or remedy, for lack of better words. Include a proposed resolution to the problem to the extent known at the time of filing. I always include a remedy, and they completely ignore it every single time. So consider it to be a writing exercise, but I always include a remedy, and that remedy could be as an assistive technology device. You can, whatever you believe that you need to do to make your child whole. And so we talked about that specific information: the name, your child's name, the address, the school, and the description of the problem. And so this is a very important step right here. When you file that in with your state education agency, you also must CC the school district, namely the special education superintendent or associate superintendent, whatever their titles are, wherever you live. But you have to CC the school. And anybody that's familiar with legal issues, you always have to make the other party aware. So always, because that can really be a problem if you fail to include the school district, to CC them or send them a separate one, but you just want to have evidence that you did. And so what happens after you file? Okay, 60 days, 60 days from the date you file, unless you agree to an extension, you will have an answer. In 60 days. It's called the letter of finding, or the LOF. So in 60 days, you're going to have an answer. Let me go back, Paula. That 60 days is important, and it's tied to ESY, because you got to have that ESY decision 60 days before the last day of school, so that you can appeal if you disagree with your team. And that appeal would be through the state process. And in 60 days, the state will say, well, we agree with the parent. This child should have been found eligible for ESY. So that 60 days is very important. Your input, the investigator is going to call you, and it's going to be kind of like an informal telephone interview. You will have an opportunity to submit additional information, and you can do that orally or in writing. That's your evidence file, which is, like she was saying, the logs, the different things that Paula was able to put together in support of her complaint. When the investigator calls you, you'll be able to tell right away what the posture of the investigator is. I've talked to several investigators, and I had one who was so rude. She was just cutting me off. She didn't want to hear, what I had to say. So she kept cutting me off. So you will understand the posture of your investigator probably 2 minutes into the phone call.
Mhm.
The district response. The district can respond and they may propose a resolution to the complaint. Now, when I did hire an advocate one time, the school district did try to contact the advocate to discuss a resolution. And thankfully, my advocate was a person of moral fiber and integrity. She said, okay, I can't talk to you about this without mom. And at that point, you can imagine the conversation ended because they didn't want to talk to me.
Mhm.
I apologize. So the most important thing there is that there can be a resolution right out the gate. And then mediation is also an option. And then independent review. The state agency reviews all relevant information and makes an independent determination. A written decision, and that written decision is the letter of finding. I have provided Paula with a redacted letter of finding for my son that will be posted and available if you would like to see what a letter of finding looks like. And also, I want to encourage everyone that if you're just a nerd like Lisa, you can go to your state educational website and you can go into the complaints, and there is a warehouse of complaints for your county where you live, and they're redacted, but you can see all of the other complaints, and you will see the patterns that your district may be collapsing into.
Mhm.
All righty. I remember I said 60 days. We can go on to the next slide.
Okay.
They must issue it in 60 days, but there are some exemptions, and that's why I said unless you voluntarily agree for the timeline to be extended. The state agency may extend the deadline when exceptional circumstances exist with respect to a particular complaint. So for me, I just had a knee replacement while my last complaint was happening, and she wanted my evidence and everything. And I told her I was incapacitated, and she agreed to extend the investigation and to allow me to heal and recover and then take time to put my evidence together.
Okay.
So that's a legal extension. And then if you go into mediation, of course, you know that that's going to kind of stop the investigative process. Remedies and corrective action. Yes, I'm glad we were able to make it to this page. Compensatory services. This is so important. I also had a draft compensatory letter where my son was awarded several hundred hours of compensatory services. That's also going to be available, redacted, on the website, because I want parents to see what the end of this process looks like when you're successful. So additional services, therapy sessions, tutoring hours. This, you can be very creative with this. Monetary reimbursement, repayment for expenses parents incur due to the district's failure to provide required services. So my situation, my son, they took his transportation and then I had to transport him. So I am legally entitled to mileage. And they've offered to pay it, but we'll see how that goes. But I have received mileage reimbursement before. Policies and practice changes. This one is, I don't know if this one is like pie in the sky, Paula. Policy and practice changes. I think if you have to have leadership, Paula, who can really appreciate the devastating impact of these violations that are occurring nakedly every single day and impacting children, not only in the moment, but into their futures.
Mm-hmm.
So a lot of times you'll see training. Oh, we're going to make them go to training. Well, now they just sit them in front of a computer and make them sit listen, you know.
Mhm.
So when I put in, I say in person, my recommendation is for in-person training. You know, they can still sit there and zone out, but it's different from them being able to sit and hide behind their computers and, you know, do 10 other things while the training is just playing. But district-wide corrections to policies that conflict with IDEA affecting all students with disabilities. So not only did I file a complaint, I also signed up to give public comment to the Board of Education. And I articulated to the Board of Education that these administrative policies that Prince George's County is drawing up under with the assistance of their legal counsel, those policies are conflicting with federal law. So, they listen to me. They don't give you any feedback. But, you know, one of the things that I know that I have noticed, because I did also go to another public, a state senator, Alonzo Washington, had a special education community forum. And I stood up at that forum, and there were a lot of prestigious people in the room, a lot of elected officials. And I talked about how my son was on the honor roll every year and every semester, and he's 2 and 3 grade levels below in reading, and that translates to fraud. That is grading fraud. And so I did see an email where Prince George's County is looking at changing their grading policy. So I'm not going to accept full responsibility for that, but I am very courageous in my pursuit for justice and standing up and attending these community forums and bringing these things to the forefront.
Mm-hmm.
And then future service provisions, ensuring appropriate services are provided going forward for the affected child and all similarly situated children. And that's what you said. It's just not about Morgan. It's not just about Blake. We are looking at all similarly situated children. We want systemic change so that these children can have a fair opportunity to have educational success, whatever it looks like, you know, respective of their functional limitations. So the next one, I don't really want to get into the due process. The slide is there. It gives you a side-by-side comparison. We already told you have 1 year for state complaints and you have 2 years for due process. Here they tell you this process is free. The due process, it says you may require legal representation. If you do a state complaint, the state agency, they're the adjudicating authority. If you go to due process, it's going to be an impartial hearing officer who is likely to be an administrative judge.
Mm-hmm.
Unfortunately, special education doesn't have to be their subject matter they don't have to be subject matter experts in special education. They come from all different backgrounds and they just get these jobs as administrative judges. I'm not saying anything negative about them, but it's I just think that the complexity of special education law, I think it requires someone with very deep credentials to be able to understand this from both sides, from the school perspective and also from the parent perspective, and looking at it through the law. So we're doing good. Key takeaway. We're doing good. And I mean, this is just, I'm trying to stay focused on what we're talking about because this is a deeply painful part of my advocacy journey. And it's been personally devastating. I've been subjected to naked retaliation, and it has really impacted not only me, it's impacted my entire family. But I feel that we needed to tell people that this is their right. This is a free tool. This is something that when the school is ignoring you, ignoring your emails, all that, you have an opportunity to take it outside of the school district to the state level and have an opportunity free of charge to be heard by an independent adjudicating authority.
Yes.
So you have a right to file a complaint when your child violates IDEA, and it costs nothing. Your complaint must be written, signed, and filed within 1 year. We're just recapping. And the state must investigate and issue a decision within 60 calendar days. And also, I want to tell you, there is a section at the end of those letters where it talks about corrective action. So, should you be successful in having violations identified, the child must be made whole. Now, I have an issue with this because the parent does not have an opportunity to contribute to this part of it, but I have raised this with our state educational agency. But the most important thing I want to say here is that after you receive that letter of finding, you need to contact your IEP team and say, we need to have, there were findings and we need to schedule an IEP meeting so we can talk about the remedy to the violations.
And I will say the best advice that Lisa gave me was for me to reach out and contact them, because I will say they did not contact me. They did not contact me. So I reached out and I was like, hey, I received this letter. They did not contact me.
Yeah. And a lot of times they have like a date. Like, I know all of mine normally say, oh, you have until October 1, blah, 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 to prove that, you met with the parent and what decisions were made on the child. But for some reason, this one that I just won, she had it bifurcated. So the violations, they want evidence by July 10th of 2026 that the computer device and the calculator, the educational impact was discussed with me. And of course, they scheduled the meeting for July 7th. Mm-hmm. So if we don't reach an agreement, they waited right up until then, and it's all strategic. They don't want to meet. They don't want to go on the record. It's the dark side of IEP. I'm going to just leave it at that. I'm not going to go too much further, but it's the dark side of the IEP process. And again, remedies can include compensatory services, reimbursement, and district-wide corrective actions. Well, also, I want you to be creative, because you need to look at your child and understand what their learning need and abilities are before you just jump up and agree to whatever they present. You need to do your homework, and you need to present also your own individual remedies. So, and then have them document in the PW, and if they accept them or not. And if they don't, they need to justify. And the reason I'm saying that, okay, say your child needs, they say, we're going to give you 50 hours of reading services. Well, a lot of times they actually hire teachers to stay after school and work with the children. They pay them a pretty good rate to do this as like a second job. Well, because of the strain with my son, I wanted him to receive his services outside of the school district. So, no, I'm not going to agree to let one of your teachers who just wants to make some vacation money, and I'm just, that probably was a low blow. But what I'm saying is that trust has been broken.
Yeah.
So my son has received our tutoring services outside of the school district as a part of these compensatory services. I
agree with you totally. Even with Morgan, with her speech services, I feel like the school had their chance. And
yes.
Once they did not do what they were supposed to do, I didn't trust them to say, hey, I can give Morgan her speech services. No way. Mm-hmm.
Right.
Yeah, so I definitely want them done outside the school.
Yeah, when trust has been broken, it's very difficult to recover from that. Mm-hmm. But Paula, if you don't mind, I do have that. I do have a quick letter where they decided what Blake was entitled to. And if you don't mind, I just need a minute to read this into the record. Sure. I want people to see when you fight for your children. When you fight for your children, this can be a winning strategy for you to help your child get supportive services. So this says, at an IEP meeting held on September 27, 2022 at Highbridge Elementary School, the IEP team awarded Blake compensatory education services for educational impact due to lack of delivery of services from November 2020 to June 2022. 2022. Now, is a lot going on with that date. Hours were also given for extended school year session of the summer of 2022. And parents, listen up. This can be your child. The IEP team agreed Blake would be provided 307.5 hours of reading, math, and written language. He will receive 285 of those hours in the area of math. And that's because they didn't have a math goal in his IEP for the entire school year. And I was new. I didn't know what to look for, and I didn't know how to find it and identify it until it was too late. And then, so of the 307, 285 would be for math, 7.5 for written language, and 15 hours in the area of reading. And I'm not going to read the rest because they go into, how it can be provided. I just wanted to say that, and I'm not trying to be braggadocious, because to be quite honest, Paula, it's personally devastating, because if my child can be awarded 300 hours of compensatory services, that is only a reflection of the neglect, the educational neglect that my child was subjected to. So there is no celebrating here.
I agree.
There's no.
And as we said before, when you have to go back and try to get your kids, I think we had a speech therapist on here. Her name was Helen, and she said, the goal is to give them their services up front. She said, because to try to go back and cram all of that in at one time, especially when they're continuing to learn, it does your child a disservice. And it does.
And they get burned out.
Yeah.
That's kind of, we're in a lull. Not only do they have my child, and this is I'll just say this, another reason that I believe that they sent my child 2 hours away from home is because they want to try to make sure that he doesn't have an opportunity to expend all of his compensatory hours, because we would normally do it after school. Well, he doesn't get home until sometimes well deep into the evening, and I'm certainly not going to take my child to mathnasium at 8 o'clock at night. So I do believe that it was a strategic reason why they decided to put him there. The silver lining is that he loves it, and it's the best thing that could have ever happened to my child. But for me and my advocacy, they have stifled me, and they have arrested my ability to be an aggressive advocate for my child. And in my opinion, it's unforgivable. And the fact
that I can't real quick
and go visit my child and take him lunch, it's personally devastating to me.
Yeah, because even with an emergency happening, you have to travel 2 hours. And I've had to do that for Morgan because she was 1.5 hours to 2 hours away to make doctor's appointments after school. Because if you make them before school, you have to drive her all the way up there. Or what I started doing is wait until after school, because I would just pick her up and go to the doctor's appointment. But that's a long day for her. Yeah. So it definitely is, when you think about it. I get what you're saying. It's like that compensatory is important, but at the same time, will it ever make your child whole? Right. Another question I was getting ready to ask you real quick. I know we're over our hour, but this is our last show for this summer, guys. We're not going to start back up until September. Just giving our staff a break. And then I have Morgan home, trying to focus on Morgan's transition into adult services. So I was going to make that announcement. Yeah, it's a lot going on right now, trying to get her set up for adult services. So not to overwhelm myself, we're going to do some reruns. We're not going to just disappear. We're going to do some reruns. And we also have someone that's going to be overseeing our website to take polls to ask what would you like to discuss, ask you some questions, give some fun facts and different things. So we're going to still stay active on our page. But one thing I wanted to ask is that 300 hours, is that something that will expire after a certain amount of time?
Okay. So I went round and round with one of the compliance officers, because she was, she wanted to say that he only has a year to expend that. Well, that has not been the case for Blake. And let me tell you why, because every child is different. So you have to consider their learning ability, their learning rate. My child learns at a very slow rate. So you can't just give him a blanket suspense date. So this is what I'm saying. You have to be able to articulate this, for your children. And then not only that, my son has fine motor coordination. He has digital access to his curriculum. So the person who's working with him has to be able to master the digital access. Like there's so many different things. So I think there are some who would like to say that this is a hard stop and a hard expiration, but I think that they would fail miserably before an adjudicator because you have to consider the individual and personal circumstances of the child.
Mm-hmm. Okay.
So I'm going to be fighting to hold on to all of his hours.
Well, this has been great. I will say this. This has been great. And for all of those that joined us and for those that didn't join us, naturally, when we put a presentation together, this is Lisa's presentation. I didn't put anything together. I just want that to be known. But we always upload it on Advocacy's page because we wanted to make sure that parents have access to this. Because again, we're kind of doing the legwork for everybody. We don't want you to feel like, okay, I don't know what to do to file a complaint. I don't know about extended school year services. This is the reason why we have these informational sessions, so that all you have to do is go to our website and pull up the slides. You can also go to YouTube and you can listen to these podcasts over and over again if you need to. If you find that, hey, I don't need it right now, but if something arises, I may need it, go to YouTube. Our library is there. You have access to it. Reach out to us if you have any questions. And again, what I want everybody to do is over the summer, July, August, take a look at our page. We're gonna be very active on our page, even though you won't see the podcast, any new podcasts. You will have an opportunity to tell us, hey, this is what we want to talk about. This is what we want to see. And again, now that I'm going through the transition in Morgan from youth to adult, I would definitely love to have someone on our show to talk about that. Because when I say this process is equally stressful, I think when you're going from one transition to another, whether it's from middle school to high school, from elementary to middle school, each transition brings about additional stresses and changes for not just the individual, but for the parents. So it is a whole lot that goes on with transitioning from Morgan. You're on everybody else's timetable. But in the midst, and I put this on my page today, in the midst of her transitioning until everything is approved, I am her 24/7 caregiver.
Oh my.
So for those that don't know, I just retired. But if I wasn't retired, I don't know what I would have done. I don't. Because it's supposed to be the budgets and everything is supposed to be approved by July the 1st while transitioning you for them to just transition right into adulthood. But how many of you guys know that everything that's supposed to happen, it does not always happen like that? Mm-hmm. So here I am, retired by the grace of God. But if I was not retired, I would have had to take a leave of absence for my job. So for those that's out there that think that you have a lot of lazy parents, a lot of special needs parents that's leaning on the system because you just feel like hey, you just want to use your child to get this and that, which the this and that ain't even worth it. That's not true. For the reality, we as the parents become the caregivers. We as the parents we're the fallback for everything. So when everything doesn't work according to plan, which in most cases it does not, we are the ones who fill in the gaps, and the gaps become bigger and bigger as they get older.
Yes.
So I just, I say this just to say, I don't know if at the end of all of our sessions, we should probably do some type of thing like this, just to enlighten people. We're not complaining, we're not crying about it, but we are just making everybody know of the struggles that comes along with having a special needs individuals. Do we love our children? We sure do. Do we regret having them? No, we don't. But there are struggles that come along with our special needs individuals, physically draining, mentally draining, and just it's a lot. So I just ask guys that you just be aware of what parents deal with, and I'm not trying to magnify a parent with special needs kids, but I am also trying to um just trying to help people to understand, because for me, I don't understand anybody that's dealing with an illness that I haven't been dealing with. So I'm not trying to magnify it or trying to have nobody giving me tissues and a pity party. Not at all. I love my daughter,
Mhm.
but there are challenges that comes along with our kids getting the necessary services and getting the basics of life, the basics of life, such as most of our neurotypical, my son, when he graduated, he was able to select, do he want to go to the military? Do he want to go to college? Does he want to go straight into the work field? Does he want to, all the things that he wanted to go to? But guess what? Our special needs individuals, a lot of times they're not given choices. And this is where a lot of the shortfalls come with them transitioning from school to adulthood, because they're not given choices. They're basically given, oh, you're going to do this. So you have this. The parents, get over it. And when we're fighting for them, most people think that we're angry. We're not angry. We're
Exactly.
frustrated at the process. Don't misconstrue our frustration for anger. And if there are times that you get anger, it's not anger at the fact that I have a special needs child, not at all. It's anger at the process. This process is so unfair. This process is so not thought out. It's not thought out. So over the summer, my goal is to definitely be the best caregiver I can for my daughter, to explore other options, to make I want to live my life in a way that I'm very transparent for the other parents, because when you reach this stage, along with all the other stages, this is why I started advocacy. It's to help you navigate this process, because this is not an easy process to navigate. So I say that close out because I want everybody to understand. We love our individuals and we fight for them just like you fight for your neurotypical kids. We fight for them. We feel like they deserve it. Morgan deserves the best. Blake deserves the best. We deserve it in every aspect of their life, whether when they go to the doctor, whether they're going to a restaurant, wherever they're going, whatever they're doing. Guess what? They deserve the best. They do. And that's one thing that I will fight for until the day I close my eyes, for
Yes.
Morgan to be recognized and be respected, for her to be given the best, not crumbs off of someone's table. I won't. I won't. So,
Yes.
with that being said, again, I may just start documenting my time with her over the summer just for people to see. Every day I'm trying to find an activity for her. What can we do? The lack of, there's not much that we can do because there's not many things out there for our special needs individuals, but I'm going to turn over every rock to find out. My whole goal is to get her out in her community so that she knows that she's a respected part of her community.
Exactly.
Yes. So I just want to just be transparent as possible with our listeners, and just to let them know we're not going away nicely. We're just not. So
I definitely wish you the best, Paula. I can't even imagine what this new transition is for you.
yeah.
Um, because not only it's a little different, you're dealing with the school district, but you're dealing with government agencies and departments.
Yes.
So I just wish you all the best, and I hope that Morgan has a wonderful and fulfilling summer, and that whatever plan that your family comes up with, that it's going to be equitable for everyone, because we want you as a caregiver to be healthy, you know, and take care of yourself so that you can remain to be a good caregiver for Morgan. So
Yeah.
wishing
And
you.
that's what's most important too. That's another thing that we neglect is ourselves sometimes, because
Yes.
we are giving so much to our special needs individuals. that you can neglect yourself. So I thank God for my husband, who definitely comes in and jumps right in and help. But it can be equally taxing on him as well, because when he's coming home from work after battling traffic and everything, my goal is always to make sure that I don't overwhelm him. So, with that being said, again, no pity, no crying for us. We're good.
We're
But
gonna
just
be okay.
again, this is just something to make people aware of, our plight. So
Yeah.
we thank everybody for joining us. Again, we won't be on for July, we won't be on for August, but we will return in September. And we
Awesome.
wish everybody a beautiful summer. And we wish everybody, please be careful over the 4th of July, because that's coming up too. So, but Lisa, thank you so much for putting the slides together. Thank you so much for just, committing to educate our parents as well as myself. Thank you.
Yes. We're all in this together.
Yeah. Yeah. So everybody, thank you, and you have a good one.
Happy summer.
Yes. Happy summer.
Okay, bye-bye.